Hi, everyone. My name's Nick Zuzor. I'm Associate Professor of Law here at Queensland University of Technology and Vice Chair of Digital Rights Watch Australia. I'm joined here by some friends, Drs. Monique Mann and Angela Daly, and we have Jessica Coates from the Australian Digital Alliance on the line as well. So the purpose of this session is that I want to provide a forum for us to really give a quick update to everyone who cares about digital rights in Australia. We're going to be, Digital Rights Watch is a new organisation started this year with the aim of better connecting the people who care about digital rights in Australia so that we can better inform public policy and debate. These calls, this is the first of a quarterly series of calls. We'll try to meet up and broadcast really quick updates once every 3 months. I'll invite people, experts from all over Australia who've been working in this area so that you can hear directly from them what's going on and how your digital rights are being affected and what you can do to help and get involved. So today we've got 3 main sets of updates. I'm going to start on privacy issues with Dr. Monique Mann, who's going to be talking about briefly for 3 to 5 minutes about the National Facial Biometrics Scheme and the Trusted Digital Identity Framework, as well as mandatory data breach notifications. I'm just muting some of these microphones, so I think we're hearing a little bit.
For the time being, this song Takayama calling in Australian lawyers for human rights.
Okay, so please, Monique.
All right, thank you for having me here today, Nick. In terms of my 3-minute update, I'll speak first to the National Facial Biometrics capability, also known as simply the capability. It enables agencies to share photographic information for the purpose of facial recognition. It's been recently announced, the first phase was announced by Minister Keenan as being operational in November of 2016, and this enables agencies to conduct one-to-one identification of people's facial images to identity documents. It's expected to roll out completely next year to enable one-to-many searching, which will enable agencies to search unknown individuals in order to identify them through information held in a range of databases across Australian jurisdictions. So currently we have access, access is through passports or visa, but it's looking to roll out to all Australian driver's license, identity databases and other sources of information, such as information collected from social media. So it might also be worth mentioning at this point that the Australian Federal Police has been recently gifted with a couple of $1 million to mine data-rich environments such as social media in order to identify and collect facial images and other personal information about people. It's important to note that this is occurring outside of a legislative framework. It's happening through administrative amendments and mutual MOUs for information sharing, and this actually bypasses sort of some additional levels of kind of scrutiny that you would have through, for example, parliamentary debate and so forth. There are a range of privacy interests at stake with the introduction of the capability, and this really depends on the actual implementation and use of the system. I think this is quite significant. Facial recognition technology can be integrated with CCTV, enabling tracking. And as I mentioned previously, it can also be used in order to kind of mine information from social media or act like as a conduit between big data sets and an individual's physical existence through their biometric information. So that's kind of an update on the trusted on the National Facial Biometrics matching capability, and that really links to the Trusted Digital Identity Framework. The DTA, or Digital Transformations Agency, is currently implementing the framework. And they're really looking to create a unique, a single identifier for all Australian citizens. And this is going to consist of 3 separate components. The first is accreditation and standards around identification. The second is an information exchange or hub It's been suggested that the capability will form the basis of this hub. And the third is identity providers that hold databases of identities, such as personal information, names, date of birth, addresses, mobile phone numbers, email addresses, driver's license, and photographs. So essentially, this will create a system in which the government, in order to use government systems and services, you will have one single unique digital identity in order to engage with government services. Digital Rights Watch, in addition to the Australian Privacy Foundation, have participated in consultations as part of the privacy impact assessment. There are a number of issues that were raised during this process, such as this is occurring again outside of the legislative framework. We're not sure whether or not it will be voluntary, and also the possibilities of data breach would have some pretty significant implications for individuals if their identity is breached online. How am I going for time, Nick?
Doing very well.
All right, so finally, on the note of data breach, there's been some pretty significant data breaches we've seen this year. One that comes to mind is the Red Cross data breach, with almost more than 500,000 individual blood donors' information becoming was leaked, including information about the at-risk sexual behaviour, which is quite problematic. And this is really just one kind of example of serious data breaches that have come to light. Currently in Australia, the Privacy Act doesn't require an organisation or an entity or an agency to notify an individual if there's a breach of their personal information. And as a result of some of the new risks, as a result of some of the new programs of mandatory metadata retention that we've seen, the Australian Law Reform Commission has recommended the introduction of a data breach scheme. So essentially, this has been introduced into Parliament, the Privacy Amendment Notifiable Data Breaches Bill. It's the latest iteration of mandatory data breach legislation. The first was introduced in 2013, the second again in 2015. These both lapsed due to elections and the Parliament being dissolved. And basically, the obligations that would be introduced from this new bill is that if there's a reasonable grounds to believe that there's been a data breach, the agency or organisation would have to notify the Privacy Commissioner, publish information on their website, and in some circumstances, if practical, inform individuals that are affected by the data breach. If there's a failure to comply, this would constitute an interference with privacy and may lead to civil penalties. However, like the Australian Privacy Act in general, there are a few notable exemptions and carve-outs, namely those around law enforcement and security agencies, and there are also broad secrecy provisions. So this really leads me to question whether or not this scheme will be effective, particularly in relation to information that's held by government or law enforcement agencies, and it's not really clear whether or not people will be notified of breaches, and if so, when or how soon after the breach occurs. So the impact of this legislation, if indeed it is passed, remains to be seen. So it hasn't as yet been passed by Parliament. It does have broad bipartisan support, and it is expected to pass when Parliament sits again in autumn 2017. So in addition to some of the exemptions in the mandatory data breach legislation, there are also some questions of whether re-identification should be considered a data breach in itself. But I'm going to use that as a segue over to Angela, who will discuss this more in relation to the criminalisation of re-identification.
Great. Dr. Angela Daly.
All right. So on that note, I'm also going to be giving an update about some privacy and surveillance developments in Australia, and starting firstly with the proposed criminalisation of the re-identification of de-identified data that Australian government agencies have released. So despite the fact we were supposed to have mandatory data breach notification legislation by the end of the year, this is surprisingly enough not come about just yet. What we have got instead is a world first, and not really in a good way as far as I and also the Australian Privacy Foundation are concerned. So basically, in response to some of the releases of data by Australian government agencies, which have subsequently been re-identified, so de-identified data that was released and subsequently re-identified by security researchers, the Australian government has proposed the criminalisation of the re-identification of this data. While one could think in some respects this would be something that would enhance privacy protection, we at the Australian Privacy Foundation have been really concerned about how the law has been crafted, particularly around a kind of supposed whitelist for security research. So the Attorney General will have to kind of approve certain people and organizations to engage in this kind of data security work. And we are concerned that this could be used as a way of stifling information about Australian government departments and agencies releasing compromised data, essentially. Also, the re-identification offence does not really deal with the root of the problem, which is government agencies releasing data which can subsequently be re-identified. So it's a case really of shooting the messenger rather than dealing with the root of the problem. And particularly as the Australian government is talking a lot at the moment about moving towards open data sets, we're really concerned that open data may be implemented without really strong data security provisions. So actually at the moment, the bill for criminalising the re-identification of data is in front of the Senate Legal and Constitutional Affairs Committee, and there is a consultation going on, and members of the public and other organisations have until the end of this week, so Friday the 16th of December, to make a submission. And I'd highly encourage people who are concerned about this to indeed make a submission, because I think this is a really problematic piece of legislation, and as I mentioned, to a world first. So no other country has actually introduced anything similar. So it's not really clear what the effects of this could be, but we think the effects are not going to be particularly good, and we'd rather see stronger privacy laws, a statutory tort of invasion of privacy, than measures like this, which we are concerned do not actually deal with the root cause of some of these problems. So that's one thing. Metadata retention kind of trundles along as policy omnishambles this year. So despite the fact the legislation has already been passed, the implementation of this scheme has been wrought with difficulties, both in terms of the kind of ISP, internet service providers, actually implementing data retention, but also around attempts by, for instance, the Attorney General's Department to encourage government departments and agencies which do not currently have warrantless access to metadata to circumvent some of the safeguards in this legislation. So this is legislation that many of us have found extremely problematic for quite some time. Australia is also out of step with international best practice on metadata, given the implementation of these laws, which have a really severe effect on individual privacy, and the few safeguards that there actually are not being well respected by agencies at the moment, and particularly the Attorney General's Department. So this kind of continues to be extremely problematic. We hope that there will be a review of the legislation soon, and we hope that the recommendation will be actually to scale it back and to require warrants to access this data. So that's something that we can hope for 2017, and something that we should be campaigning about then as well, and particularly highlighting all the myriad problems there have been in the implementation of these really bad laws. Also on the topic of metadata, one of the biggest cases in Australian privacy law in the last few years continues to trundle along as well. So this is the case with involving former journalist Ben Grubb's telephone metadata. The case, I think, has been before the federal court, and the Australian Privacy Foundation actually kind of intervened with an amicus brief on the circumstances of the case. I think we're still waiting for the decision from the federal court, but this decision will decide whether certain kinds of metadata, particularly I think IP addresses, can be considered personal information for the purposes of the Australian Privacy Act. And if so, that could have an important impact on how personal information is defined and used by various organisations. So we'll see whether that decision is handed down before the end of the year. I think we're hopeful it will be, but it may not. So that may be something else to look out for in 2017.
Sounds like there's a lot going on in early 2017. I guess the last one question I'd like to know is, we've been waiting for, the Australian Law Reform Commission has recommended again the introduction of a personal right of privacy. Any chance that we'll see that introduced in 2017?
I would like to see it.
I think, unfortunately, I think it's kind of unlikely. As far as I'm aware, the federal government at the moment does not support the introduction of a tort of serious invasion of privacy, and I think made some comments around that when the New South Wales Law Reform Commission also recommended the introduction of a law around those that issue. So I'm not optimistic, unfortunately.
All right. Well, on that not optimistic note, we might switch to copyright issues immediately, which has also been there are a series of very important issues currently on the legislative agenda. I'm pleased to introduce here Jessica Coates, who is the Executive Officer of the Australian Digital Alliance and one of our foremost experts on copyright policy. So please, Jess, tell us what is happening in copyrights. I think you're muted, however. Sorry, Jess, I think your microphone is muted.
I'm still muted. Very clever. Thank you, Nick, for the lovely introduction. So yes, as Nick said, there is actually something, in fact, there's several very exciting things happening in copyright reform at the moment, which is something you don't get to say very often. So it's very exciting to be able to talk about this. And most of you will probably have heard about both these initiatives, I imagine, if you're at all interested in the area, because unfortunately, they're now getting a bit old. They're exciting, but they've been dragging on for longer than we wanted to. So they're both a year or so old, what's been going on. But there are some more recent updates that we can give about where they're at. So the first one is a copyright bill called the Copyright Amendment Digital Access and Other Measures Bill, which was released as an exposure draft almost exactly a year ago, 23rd of December at 3 p.m. 2016, a great day, 2015, I mean, great day to release draft legislation. And this bill basically comes out of the Marrakesh Treaty for providing access to material for people with visual impairments. It's got a very long title beyond that, which basically aims to introduce international standards for exceptions for providing access to people with to material with people with disabilities. Australia basically already says that it complies with the treaty, though there are some people who disagree with that. But the government said that even though we comply, we want to be best practice, so we're going to introduce some changes to improve our system at the moment, which is really great. And whilst they were introducing these changes, they had to put together a bill. They thought they would put in a few other interesting and fairly non-controversial matters at the same time. If you're writing a copyright bill, you may as well try to put a few things in. So it's been often called the low-hanging fruit bill. It involves a number of different measures, as well as the disability measures, a number of other measures that I like to think were sitting on a list in the public servants' cubicles, saying things I would like to fix about the Copyright Act, that are primarily non-controversial, but still really quite big and impressive amendments. The first is that we are fixing our disability access exceptions. They're going from a statutory license, which is quite fairly broad and free, but fairly bureaucratic as well, to a new flat exception and a new fair dealing right. Probably they'll be very broad. They'll basically allow almost anything that you need to do to provide access to somebody with a disability. Probably one of the most significant changes, though one of the least commented on, is the fact that the new exceptions will apply to anybody with any disability, not just visual or print disabilities, which the previous ones were limited to. So it means that now people with deafness or physical disabilities like cerebral palsy, etc., that stop them from accessing material will be able to also make access to of the same exception. So that's really great. Very non-controversial. Definitely will pass if the bill goes through. There are several other very non-controversial amendments. There's some simplifications of the educational statutory licenses. They're the licenses that allow schools to copy material in return for payments to copyright owners. Very complex at the moment. The schools and the payment organisation decided that they could do a better job, and so they've sat down and come up with mutually agreed amendments that would vastly simplify that. So they're in there, again, very non-controversial, could make a real difference to schools and how they can, how they can access material, which is great. There's changes to preservation exceptions for libraries and archives. They're pretty complex at the moment, and say such useful things as you can preserve a work once it has already been lost, destroyed, or damaged, which is a great preservation tactic. But they are, it's being fixed to basically be a very open-ended exception that allows almost any preservation in any format and any number of documents that are required by best practice. So that's great. And probably the measure I'm most excited by is the ending of perpetual copyright in unpublished works. So there are literally hundreds of millions probably of unpublished works like letters and PhDs and diaries in the collections of our various universities and libraries, etc., which all currently remain in copyright forever, perpetually. Which means that the, Captain Cook diaries and the Jane Austen letters that are held by the National Library are still in copyright, and we're supposed to find somebody get permission if we want to use them. So the good news is that this will end that, and you will have, they will have the same copyright term as other as published works, so they'll just have a normal copyright term, same with other works that they're similar to. And interestingly enough, if you can't find the copyright owner of work, if it's an anonymous work or for some other reason you can't identify the copyright owner, there'll also be a flat copyright term of 70 years. So that's a partial solution to the orphan works problem, which is quite a significant thing internationally. So fingers crossed that that goes through. And the result of this would be literally hundreds of millions of works going to public domain on the same day when it comes into force in a few years' time, which would be fabulous. And we have to come up with something really fun to do to celebrate that.
So that sounds great, Jess. Do you expect this to be introduced fairly soon in 2017?
Unfortunately, no. The government has been saying that they will. They initially had good, very strong intentions towards that way, but the last set of amendments, which are extending safe harbour liability, has turned out to be a bit controversial. Seems to be delaying the tabling of the bill, though it could also just be the government's legislative agenda that it's stuck behind, probably a combination of both. The government is still saying it will be tabled very soon. So it could be very soon in 2017, but we just don't know. Whether or not it will have the safe harbour amendments in it when it is tabled is also a big question mark now. But those other amendments I mentioned, all non-controversial, all should go through when it happens. That's really good. Hurrah!
And the last issue then is that we're still waiting on the introduction of a bill introducing fair use and the Productivity Commission's report. Any news on that?
Yes. So the Productivity Commission has, it has this report that they've done on intellectual property framework of Australia. They released a draft in April, really big recommendations. A lot of them non-controversial, but the biggest one was that we should adopt fair use. Also, probably should be non-controversial, seeing it's the 6th time this has been recommended by an independent body, but unfortunately, of course, it isn't. It's a very hot topic. The word on the street is that it will be released, the final report will be released very, very soon. It's already gone to government. I understand that they have it all ready to go, and it could literally be tomorrow. And there is a very good chance that it will be before Christmas still. If it doesn't come before Christmas, expect it early in the new year. It has to be tabled by 14 February. So that's the latest they can table it under the Productivity Commission requirements. So that's very exciting. It will definitely be out soon. It will definitely recommend fair use again. Well, okay, I'm just assuming that, but so is everybody else. The government isn't planning on providing a response straight away. They're planning consulting more on it. So there'll be another chance for people to come back before we find out if it leads to anything interesting like a copyright bill or a white paper or anything. There are rumours that it might, so that could be really exciting. We could have a fair use bill next year, but that would be a highly controversial issue. It might be one of those bills that's basically designed to die. But it would be a big step forward if we did manage to get that far.
Okay, so that's a packed agenda for 2017. There's a few optimistic points, I think, that have been raised, but there are also a lot of things that are quite concerning to all of us here. So this is something that that we at Digital Rights Watch, and obviously everyone else that you've heard from today, and many other people around Australia, are very keen to get public input on and to really represent the public interest in both legislative and other public policy arenas. So please, I'd like to first thank everyone who's joined us for an update today. We'll be doing another one of these in early 2017, likely early March. But in the meantime, if you would like more information, you can find our mailing list on digitalrightswatch.org.au, and please feel free to get in touch with us or at any time if you'd like more information about what sort of things we're doing and how you might be able to get involved. So thank you everyone for joining us, and I hope to see you soon.